We'll go to Senator Patterson.
Chair. I have some questions about the Ombudsman's report. There's obviously a range of issues with it, but most kind of tellingly, I guess, the Ombudsman entitled their report "Following the Law is Not Optional." Their media release was entitled "Following the Law is Not Optional." And just in case we missed it, in their executive summary there is a bold sentence that says it is not acceptable that an agency knows for years that it is not following the law and chooses to continue to not follow the law. Mr Hazelhurst, first to you. How can you account for a very damning report like this?
Senator, we acknowledged in our response to his report and with our colleagues from DSS that notwithstanding all of the contextual issues, which I'm happy to provide further information about, we should have done better. It's a complex interaction that was unintended with some amendments that were made to the legislation. Implementing the law as it then stood and as it now currently still stands, notwithstanding there being a bill now before the Parliament to correct that, would have led to perverse outcomes and, in fact, harm and confusion. Nevertheless, following the law is not optional. And so, whilst there were several attempts to get legislation changed, as in bills drafted but not introduced, we should have done better. So we haven't tried to make any excuses around that. And indeed, were there legislation not to be passed, I have made a decision that we will change the systems to implement the law as it currently stands, notwithstanding the confusion and concern that that would lead to. It's connected, of course, to the earlier conversation about the whole legal compliance and remediation program, and there are a number of matters where the advice to us has been you really must get the law changed at the next available opportunity, and that is what we're working with our Minister on, and she's working with her ministerial colleagues on. And there's no secret, they're referred to in the table.
Sure, but the report also says, and I quote, information provided to our office by Services Australia shows that, as at the time of responding to our request for information, it was yet to brief the relevant minister about its choice not to apply the law enacted by Parliament. In brackets, the minister was subsequently sent to brief on the 30th of September 2025. So if you knew that you weren't following law because it had these anomalous, implications, and you thought that wasn't optimal, you can't have tried to change the law very hard if you didn't tell the minister that the law needs to be changed.
There'd been several attempts before the minister was the minister. We'd been working with the minister on a range of issues, but we had not provided a detailed brief on that specific one. And that was a failing on our part. We should have done that. And so we did that in detail in September.
But your evidence was that you tried to get the law changed.
Well, this issue was first uncovered in 2019.
Yeah,
so it's been a long-standing issue in terms of... I was briefed at the end of September.
I'm not trying to make a partisan point here. I make no criticism of you or the government. I'm asking questions to Services Australia about their awareness of the law and their efforts to correct the law. You just said in your answer earlier, Mr Hazelhurst, that you tried several times to fix the law. But if you didn't tell the minister about this issue, how were you really trying to fix the law?
So those occasions, Senator, go back as far as 2020.
Yeah.
When I wasn't here,
No,
neither
sure.
was the minister.
When I say you, I mean the Royal You, the agency.
There has been... my understanding is there had been a lot of engagement between departments and us with a view to changing the law.
Yes, but just not telling the minister until September last year.
A detailed brief arrived, yes, in late September. before that and since my appointment, we have been working on collating all of the different issues that were emerging over time, and so we had been in engagement on that. But all of that work, which has now been consolidated and I think provided in questions on notice, it forms part of that work. But it's a huge piece of work. I can't, tell you how much has gone into trying to identify all of the issues. And as I said, we've had a new one arrive in January, I think. Was that the urgent advance payments?
Sure.
New legal advice in January about another issue that we add into this. And so that, in terms of that, we were working on it. But yes, a detailed briefing wasn't provided until late September, and
Senator, if I could just add, so in terms of those previous attempts to change the legislation, on those occasions Services Australia was working with the Department of Social Services as their minister is responsible for the legislation. So that's the way the previous attempts had been made. Obviously, it was still a big error not to brief our own minister at those points in time. But yeah, that's just clarifying.
Sure. So my understanding, Minister, is notwithstanding the detailed brief being given on the 30th of September, that you were first made aware in July 2025. Does that sound right? I think that's from the report.
I'd have to check that, but it could have formed part of the overall, we've got a lot of different issues going on here. How are we going to fix them? Do they require legislation? Do they require a policy fix? Does it require engagement with DSS? And in part of those discussions, but it was certainly later that I was briefed on the detail of the 35%.
Sure. So let's say, for the sake of the argument, between July and September, you became aware, Minister. Mr Hazleworth, correct me if I'm wrong, you started at Services Australia in January 2024. When did you first become aware that Services Australia was not following the law?
In respect of, I'd need to take that on notice in respect of this specific item, Senator. Over the course of my first few months in the role, I became aware of more and more issues like this one, some of which there was no longer a legal issue, but there was, as Senator Allman-Payne was questioning us earlier, there was a remediation task. But to be frank, there was no program. There was no gathering of those things. So from about October of 2024, we commenced a process of drawing these things out and together. As is reflected in the question on notice response, a very substantial proportion of them we had corrected the issue prospectively, but nothing had been done yet to address it retrospectively. Sure. And that's been a big part of what we've been, frankly, wrapping our arms around to ensure that we have a considered approach to that, because prior to that we didn't actually know how many of them there were.
Sure.
And so the program developed a centralised register, and in design of the program, Senator, we've taken into account the Royal Commission, the Robo-Debt Scheme, Ombudsman's report, the ANAO audits, and so have constructed it so it's a centralised register. There's then a ready tool and way of engaging with responsible policy agencies, with escalating to Mr Hazlehurst and the Minister issues that are there, and to drive forward towards pathways of solutions. And then we also have a closure process where we don't simply take something off the register, but we actually have a formal governance around it. So it's much more gripped up how we're seeking to address these issues now than in the past of the period you're discussing.
Sure, but I mean, this is not ancient history, right? This is in the last couple of years. And Ms Hazlehurst, I appreciate you did not cause these problems, you inherited these problems. But sometime in 2024, you're not sure when, you would have learned that Services Australia was breaking the law and you did not inform your minister for at least until July 2025. So we're talking at least 6 months where you knew Services Australia was not following the law and you didn't tell your minister. Is that right?
Senator, I'd need to take on notice precisely when, as the Minister described, we commenced the process of engaging both the current Minister and the former Minister in the lists of issues that we were coming up with. So I'll need to take on notice exactly when that was. But there was the first detailed briefing that we provided to the Minister on this specific issue was, as you referred to, and as the Ombudsman pointed out, September.
But in a post-Robodebt environment, surely one of the first things you do when you are told that Services Australia is not following the law is tell your minister.
Well, yes, Senator, and I'll take on notice exactly when and in what form we provided further advice. There was no hiding of these issues. They were drawn out as a list of concerns that we had and that we were addressing. It was a question of the detail of the briefing, and we didn't do it properly, and I acknowledge that. I'm not sure what else I can say.
Yeah, I'm not ascribing motive. I have no idea what the motives were, and I don't want to impute any. So I don't know whether you got quote hiding or not hiding, but certainly the minister was not told. The agency knew it wasn't complying with law, and the minister was not told.
I'll just repeat what I've already said, Senator. I'll take on notice the question of specifically when these particular issues were brought to relevant ministers' attention. The question around this set of issues has been raised over time with both ministers, the former minister and the current minister, and naturally enough, they've been very concerned about it.
Sure.
As have I.
But wasn't in the incoming ministerial brief to the new minister after the election?
I would have to check that. I think there probably would have been mention about legal and compliance issues, but I'll check. I'm surprised. I thought they were all being released.
They have been.
Yeah. I'd have to check. But look, I remember from coming in, at our briefings, conversations about a range of issues, and the discussion I had was, can we pull it all together? Can you be clear with me about what requires legislative change? Can we prioritise the most, because it was clear to me there was so many, of which, what are they, 144 of which some have been completed. It was kind of, I need this information in a way where we can work out a pathway through all of these things. Some of them require policy change, some of them require ICT change, some of them require legislation. I want to know what they are, and then we can start dealing with them, which we've done in that first bill. So if we prioritise the legislative response, because it isn't optional to follow the law, we've got some of those changes through the next bills coming through, and there will be more after that.
But Minister, what is your expectation of agencies and officials in your portfolio that if they discover they're not following the law, do you expect to be notified promptly?
Yes, I do.
And do you think it was sufficiently prompt in this instance?
Look, I've had a discussion with Services Australia about that. Like, I think, and Minister Hazelhurst has said, it would have been a more detailed briefing earlier would have been better. But I also acknowledge the huge amount of work that is underway to try, and the fact that advice is changing. So, for things that we believe the intent of the way the law is, the policy is that things happen this way, to then get advice that say that it's, you don't have legislative authority for that, or it's being interpreted in a different way. Then you have to deal with that as well. So it has been some changing advice over a number of the issues raised in the work that's being done. Sure,
but again, in a post-Robodebt environment, surely as a minister, your instruction to your department and agencies in your portfolio is, please tell me immediately if you are not complying with the law.
Yes. Yes.
And this was not immediate. I mean, the Ombudsman's made that incredibly clear.
So, Senator, we've said we've agreed with that.
Over and over.
So we agreed in our response. Both the Secretary of DSS and I agreed
But-
that. So I'm not.
Sorry, Mr. Hazel.
What we put in
you agreeing to that is not the end of the matter, right? That does not mean the Parliament can't ask questions about it. That's not mean the minister proposition can't be put to the minister.
I'm just
This
not
is serious,
disagreeing with you.
and it's legitimate area of inquiry.
Sure. No. I'm just saying I'm not disagreeing with you. We should have done better. We've got put in a range of processes and a program with appropriate governance now to ensure that it doesn't happen again.
Sure, but I'm sure that was also said after Robodebt, that we'll put in place processes that will make sure this doesn't happen again.
Well, at one level, this is a response to Robodebt. At one level, the period from the middle of 2024, October of 2024, was still through the period where we were implementing changes as a result of Robodebt, and this was an area of concern, and that is why we've introduced this program. This particular issue we should have briefed, absolutely should have briefed the Minister in detail earlier. No question.
And I think the other thing that's influenced by the Robodebt lessons and recommendations is, getting legal advice on a whole range of things that have been done for a long time that people thought were compliant, that, there is a different opinion on the authority there. That definitely has had an impact.
Okay. Chair, thank you.